let's go ahead and get the afternoon session underway. This is the adult track. If you are looking for the juvenile and youth track, that is across the hallway in the hibiscus room. This is going to be the adult track, and we're going to begin with a presentation by John Petrila. John is Vice President of Adult Policy for the Meadows Mental Health Policy Institute and an attorney with 40 years of experience in mental health law and policy. He has been general counsel to the New York State Office of Mental Health and was the first director of forensic services in the Missouri Department of Mental Health. He's a national expert on data sharing and wrote a chapter on confidentiality for the 1999 Surgeon General's Report on Mental Health. He's going to speak with us today about information sharing in criminal justice and mental health collaborations, working with privacy laws. John Petrila.
Thanks very much, Justice Boyce. I'm sure that most of you listening to Chief Acevedo were thinking, I wish I was Petrila and could talk about Hipaa right after that. So I have the privilege and you don't. So it's great to be here. I also know that probably when you told your partners, your children or whatever, I'm going to a conference in Houston, they said, what are you most looking forward to? You said, talking about Hipaa after lunch. I'd asked Christy and Justice Boyce to put me on during the cocktail party, but because I thought that'd be an even better slot, but they refused to do so. So I'm going to, I somehow become known as a national expert on Hipaa, which says much more about the field than it does about me. This is not an area lawyers gravitate toward. And so I remember a friend of mine who was far down this rabbit hole long before I was, who went to one of the first national vendor conferences on Hipaa. And when Paul came back from that, I said, what'd you learn? He said, well, if they don't know how to spell it, you probably don't want to hire them. So the field's moved a little bit since then, but not that much. So this will be exciting. It's going to be overgeneralized. At least some of you at the end will go, that was the most overly generalized, unnuanced presentation I've ever heard about Hipaa. And I have 42,000 points I'd like to make in response, to which my response will be, yes, that's the point of what I want to do for the next 40 minutes. I want to overgeneralize on one point. Virtually everything you're told about information sharing is incorrect, and that both Texas law and federal law in general support the sort of information sharing that's indispensable to doing the smart justice that the chief was talking about, to doing the integrated care Andy Keller was talking about, and to doing the work you folks do in your community. So that's the main point, and now you can rest your heads gently. We'll have soft music coming in the room. When I start reading the regulations in a monotone about 10 minutes in, the lights will go down. The soft music, people will come mist you from the spot. It's going to be an excellent kind of day. So the chief talked about someone who'd been arrested 55 times for trespass. A couple weeks ago, I had the privilege of going with Justice O'Neill to visit Judge Hohengarten's court in Austin, where they were doing case adjudication in the judge's conference room. And they talked about someone who they were trying to resolve their situation, who was in on his 69th arrest. And you folks know these cases, right? I've talked to judges in big urban jurisdictions. A colleague of mine, Steve Leifman in Miami, who was supposed to hear almost 2,000 cases a month in his court, because they have like rules about how many cases you're supposed to hear in a state like Florida, because there's too many cases. And eventually, if you don't hit your mark, eventually, if it gets bad enough, a justice from the Supreme Court will call as a reminder. But Judge Leifman knew of his 2,000 cases a month, the 10 or 12 folks who showed up all the time. Now, why is that relevant to this? It's relevant to this because when it comes to information sharing, we treat it like Groundhog Day. This guy's in for the 50th time. What can you tell me about his mental health? I can't really tell you anything. Why? Confidential. What's the, that's kind of where we start. So I'm going to talk about this topic in a way, starting with a case study. Many of you, a lot of you went to law school, right? Nothing better your first year. Let's do case studies and brief the case. Like, oh my God, please, why did I go to law school? But how does information sharing work in practice in many places? this is what the answer is. You can't do it. You can put any language you want up there, you can't do it. The reflex response to virtually any question about, can you tell me something about this person, is no. Why? Hipaa. Have you read Hipaa? Not really, but I've heard about it. And I understand that if I violate it, if I'm not going to be publicly executed, I'm at least probably going to lose my license, my job, whatever, right? One of the things that happened with Hipaa was, remember, some of you may remember President Clinton. Bill Clinton, president. People are like, yeah, really? This is what we're talking about? I noticed, by the way, another application of Hipaa. I'm walking around because you try to see people's names. Some of you just are like Region 7 and Region 9. So I'm assuming this is like Hipaa taken to the extreme. I can't tell you I can tell you the region, but I can't tell you region of what. But I'm Region 7. Great. Always wanted to visit Region 7. Thank you for that. So when Hipaa was enacted, it was the last remaining crumbs of the Clinton healthcare reform effort from the 1990s. And one of the reasons it survived was the middle initial, which is P for portability. The thought was that there had been this freezing of the workforce because people couldn't move around the country, in part because they would be denied coverage because of pre-existing conditions, but also because as people did move around the country, as healthcare was becoming more sort of national in scope, as information was moving from paper records to electronic records, that it became useful to think about the transmission of information as part of health coverage continuity. And so Hipaa was enacted in large measure after Congress kicked it over to Health and Human Service to figure out, as a way to try to assure continuity of care. Now that's completely at odds with all the myths about it. But in fact, that's what Hipaa does. In fact, Hipaa was criticized by the American Psychiatric Association when it was first enacted as being too open to exemption, too open to law enforcement access, to which the congressional response and the response of the Justice Department was, we're not interested in individual privacy, but we have to be able to churn through records to look for Medicare fraud. And so even when Hipaa was enacted, there was a lot of debate about, was it too restrictive, was it not restrictive, whatever. What then happened was, and this is like I told you, this will be, I'm going to overgeneralize everything, so just bear with me. What happened was then all these conferences started being held. Software vendors and lawyers started going around conferences. Software vendors saying, buy my product, you will be HIPAA compliant for life with $1 million fee each year to refresh you. And lawyers started threatening sort of people with the adverse consequences of confidentiality violation. What they never said, and rarely say now, is there's no private cause of action from Hipaa. There's no private cause of action for the violation of any federal confidentiality law. Now, what does that mean? If you violate my Hipaa rights, whatever they are, I can't sue you as an individual because that's not available. So there's no malpractice equivalent of a Hipaa violation. The Attorney General has enforcement authority. The Office of Civil Rights has enforcement authority. But this notion that everyone was going to hang at dusk or dawn or wherever people get hung for Hipaa violations is just not rooted in fact or law. But that created this enormous kind of sense of trepidation and fear about what if we violate Hipaa. So it becomes easier just to say, I can't share. Because if I can't share, I'm not going to get sued. If I can't share, it's just the law made me do it. And so that's kind of the myths that have been created about it. So let's talk a bit about Hipaa. This says we abide by Hipaa laws to protect your privacy, and this guy's saying that explain these hospital gowns. One of the things, so we focus on privacy, but not always in the right places, right? So to speak. I actually tried to spend, because as all of you know, what could be better than the internet for wasting time on things that don't matter? I tried to track down, because I thought, if nothing else, you'd remember this from this talk. Who invented the hospital gown and how old is it? And even Wikipedia does not reveal who invented the hospital gown. It probably goes back to Roman times in the baths or something. And there's some interesting studies, actually, and this is something to think about when you're worried about hospital care and not privacy when you're in there. There's been some studies recently that suggest about 65% of patients actually could be clothed with pants or whatever, with no problem for care, but that in general, 9 of 10 patients look like this guy showing up, maybe a little bit better. So that's an issue with privacy. Elvis. This is the only HIPAA presentation you'll ever hear that features Elvis Presley. Now why? Because when HIPAA was enacted, there was all this kind of retreat to practices that in the face of it were simply ridiculous. So there were nursing homes that quit holding birthday parties for patients because they believed that to reveal that the patient's birthday, which is actually a data element under protected health information, would violate their HIPAA rights. My father was in a nursing home for 3 years before he died. He had very little memory except of what was in front of him at any given moment. The worst thing on earth you could have denied him was the one day a year he got to eat birthday cake. He would have put his birthday on a billboard at the South Bend airport and said, John Petrila was born on May 22nd, if it meant he could have a piece of birthday cake. There was another doctor's office that would assign people fake names because they didn't want to call the real name in the waiting room. And so people could be Elvis. I'd be like, last week I was Fat Elvis. Can I be Skinny Elvis this week? Or I want to be John Lennon, really. And so it just got taken to absurd measures. And one of the really interesting things, if you look at the Office of Civil Rights website on HIPAA, there's all these questions to which the practical answer almost always is, yes, you can do that. Can you call a patient by name in the waiting room? Yes, you can do that. Do you have to give a patient a choice between Big Elvis or Thin Elvis? Yes, you have to give them that choice as a matter of autonomy. But so we've retreated to kind of these positions, right? Now, in your lives, none of you have these attitudes about HIPAA because everyone here is enlightened, and so confidentiality and information sharing has never been an issue for any of you, right? You're just here for the Elvis jokes. So HIPAA is even getting blamed lately for bad football. So this was the Miami Dolphins, which are really sort of in the race for the worst quarterback in stiff competition. So their quarterback got hurt, and there was a dispute between whether he was ready to come back or not. So they asked the coach, what's his condition? He said, there's some kind of HIPAA law, I can't tell you. So apparently football coaches are now covered entities under HIPAA. And so HIPAA now is responsible for the condition of the Miami Dolphins. Yesterday, one of the Dolphins players' agents said that this coach is incompetent, which I assume meant that his knowledge of HIPAA is lacking and not about his football acumen. So let's come back to real life in Texas. And I want to make 3 points. The first is Texas law permits information sharing in virtually every situation you will face. I'm going to illustrate why that's the case. HIPAA does not block information sharing in those situations, though occasionally you have to make accommodations for it, and I'm going to explain why. And the third is this is just not only my opinion. I'll end with a quote from a letter from the Department of Health and Human Service, or the HHSC shortly. So these are the 3 points I want to make over the next 7 or 8 hours that I'm going to talk about this. The other great thing about HIPAA, when it was issued under the Clinton administration, then it was withdrawn under George Bush's administration, then it was reinstated. It was published under the administrative simplification part of the federal code, which means it's supposed to be pretty non-controversial and easy to understand. And there were 16,000 pages of comments that were provided the federal government as HIPAA was released. So if that's our model for administrative simplification, one is hard-pressed to know what something less simplified would be. But how many of you have heard of HIPAA before this talk? And how many of you, this is actually probably violates a privacy issue, but how many of you actually read all of HIPAA? And how many people have, we're having a small support group later, I'm just trying to identify. It's going to be a small, dark room with a lot of alcohol, and in which case then we'll have to talk about 42 CFR, which will divert the... How many of you have had people tell you what HIPAA meant? Right, so How many of you think the person who told you this actually had read Hipaa? And again, it's not to discount the fact that people have, it's just that it's the retreat, right? And so it's in the air as something that makes life unworkable. And so it became effective in 2001, again, after being put back and forth in the transition from the Clinton to the Bush administration. Interesting treatment of correctional facilities, which initially were in as fully covered by HIPAA, then they were out, and now they're in this modified position that almost a condition position I'll talk about. Compliance was due in 2003. It sets a national floor for confidentiality. Now, what does that mean? It means if a state law is more protective of HIPAA, more of privacy, then the state law applies. If in a rational, well, I mean somewhat of a rational world, it could have established a national standard for information sharing. But it didn't do that, in part because health law historically has been very much a function of state law. And so there was respect for federalism for an effort to let states do things, sort of experiment in the sort of the laboratory of federalism. But this issue of when is a state law more protective of privacy than the federal law sometimes becomes a vexing issue. And I'm not going to go into it, but simply note, HIPAA sets the bottom line, and then states can be more protective. New Mexico, for example, just as an example, has a statute that is so restrictive they can't do anything with continuity of care. And so their statute applies, not HIPAA, because it's much more protective of privacy, even though it's much less protective of continuity of care and common sense. So there's, as I said, a lot of misunderstanding. There's confusion over whether the law applies, and there's a misplaced fear of liability. If you take one thing away from this, you cannot be sued in a private cause of action. I cannot sue you if you violate my HIPAA rights. Doesn't mean you should go out and do that, but I can't sue you. And again, that's one of the common myths about HIPAA, that there'll be all this litigation against you, and there simply won't be. Now, I can imagine a case so egregious, and there have been a couple so egregious, that the courts have begun to flirt with the notion of permitting a lawsuit, but they haven't gone over that line. In most states, there's the ability to bring some lawsuit for breach of privacy or whatever, but those are hard cases to make and sustain. And so liability is a misplaced concern here in most respects. So let's talk about Texas law. That was also the shortest discussion of HIPAA you will ever hear during a HIPAA presentation. But why do I want to come back to Texas law? Because Texas law is largely designed to be a fit with HIPAA. And there's, in 2001, the Texas Medical Privacy Act, which was recently amended in 2011, explicitly sort of makes Texas law and HIPAA more or less the same. Now, there's some differences around the edges, but in terms of basic provisions, they're the same. The 2011 amendment went a little bit further, but it was designed in part to get at the marketing of healthcare information. And again, if you go back to why did HIPAA evolve, and it's the same reason the 2011 Texas legislature amended the Texas Medical Privacy Act, it was because health information was being marketed routinely, right? So one of the most egregious examples Congress heard about was from women who had lost a child either early after birth or during pregnancy, and they were getting mailings from toy companies at developmentally appropriate stages because the toy companies had bought information from the health group. And so it was marketing that largely motivated Congress to want to deal with HIPAA in addition to portability of healthcare coverage. And it was the marketing of health information that caused the Texas legislature to go back in 2011 and increase the rules and penalties around the marketing of health information. But basically speaking, HIPAA and Texas law are largely the same by design. Ohio is another example of a state that's done that, and increasingly it's the trend among states, and Texas was the first, one of the first, to try to conform state law to federal law to avoid this confusion over which law applied. So that's a point. And Texas law also, as I'm going to say, not only permits exchange of information, but in some cases mandates it. So we talked earlier about the Intercept model. Basically, as I think Andy Keller said today, and is in your materials, and many of you have dealt with this in your own localities, when we use the Intercept model, it's a way simply to try to break the criminal justice system process into a linear process, which is by its definition artificial, but does that, and then sort of where are different points at which people come in contact with law enforcement where they might reasonably be diverted into treatment. And so that's more or less what it is. And again, those of you who've gone through it recognize I've oversimplified it, but that's the only way to get through a post-lunch talk is oversimplification. Now, the point I make with this is that if you think about individuals going through this system, every transaction involves an exchange of information, somebody wanting information, somebody asking you to give them information. And so I've used in a number of places in Texas, but also around the country, this model as a way to map information sharing. And so what you find is those transactions break themselves down differently. So at the front end, as I'll talk about briefly in a minute, I'm always afraid when I poke this, I'm going to stick myself in the eye and I'm going to come out with a, there we go. All right. As I'll show you in a minute, at Intercept 0, which is purely treatment providers, talking to treatment providers, if you put it in that context, under both Texas law and federal law, there's no problem with exchanging of information. So if a provider wants to know from another provider, has this person been treated in your facility, you are permitted under both federal and state law to share that. Now, does it mean you should? Does it mean we throw informed consent out the window? Does it mean you all abandon sort of your ethical practices around respect for autonomy and all that? No. But the law permits it. And so another point I want you to understand is sort of the law permits a lot. Whether you do it is a judgment question, but this is a sphere in which the law permits a lot, and that's part of the point here. So again, as people go through this, I'm going to come back to this map in a bit. What is useful is to apply the law as it actually exists to the individual exchanges of information that occur or might occur as people go through this process. And when that occurs, you find some things actually there's a legal parameter, other things there isn't. Other times it's simply information isn't available. So it's a very granular process to track information flow as people go through this system. And so we're going to, I was going to try to say something even funnier, but that won't work. So we're going to come back to that. There's three key statutory provisions that are relevant here in addition to Hipaa. One is the Texas Medical Privacy Act, which, as I said, conforms Texas law to Hipaa. What's interesting, though, and most relevant to you all, is it exempts the Exchange of Information Act, and I think Christy put a letter and some materials about 614 in your packets. So the Texas Medical Privacy Act applies in context A, general treatment, other sort of things. It does not apply by its terms to addressing special needs offenders, which is Section 614, which is the relevant statute to you all here for virtually everything you do. Okay, so Texas Medical Privacy Act is relevant if you're in private practice, you're not doing criminal justice stuff, you're just out there, or hospitals. That's the basic Texas privacy law. There's a Mental Health Records Act, which I'll talk about in a minute, because all states carve mental health out of their general health confidentiality law for a lot of different reasons. Then there's the Exchange of Information Act, which is most relevant to the work you're all talking about here, all right? So those are the three. There's all good things come in three. So the Mental Health Records Law of Texas permits these disclosures without consent. And again, it doesn't mean we put consent to the side, but what does the law permit? Texas Mental Health Code permits exchanges to government agencies required or permitted, audits and payments, treatment, medical or law enforcement in an emergency to correctional personnel for care or treatment. In other words, the mental health law of Texas, like the medical privacy law, largely tracks Hipaa. Hipaa permits unconsented disclosures of information for treatment, payment, and healthcare operations. So that's the Hipaa law. This is the Texas mental health law. They're basically the same things. Does it mean you exercise all that zone of discretion that the law gives you and throw out informed consent for waivers? No, but it's simply what does the law permit? And in the context of an emergency in particular, this becomes really important, right? And again, to use Andy's example from this morning, if you're in the emergency room with a stroke, they're not going to try to wake you up to ask, can we get your medical records? You good with that? Everything good? You treat, right? Because emergencies trump a lot of different types of situations. So this is the mental health law relevant to the provisions or the transactions in that that would affect this. So at the point of intervention, right? Intercept 1, not intercept 0. Law enforcement, the chief talked about law enforcement with a mental health professional in the car out for early intervention, right? And this is what Dallas is doing. A lot of communities are getting to this, to try to pair a mental health professional with a law enforcement person in the car at the point of earliest intervention. Can the mental health professional in the car learn about whether that person has been in treatment? Yes, under both Texas law and federal law. And I only mention federal law because federal law sets a minimum standard, and if federal law didn't permit it, and Texas law did, then federal law would be the predominant law. But that's not the case. They both are clear on this question. How about if it's just a law enforcement person in the car? I was in Akron, Ohio, because I have an exotic life, and it was winter, talking to folks there about information sharing and mapping. This was great. You talk about situational depression. This was right after LeBron James had left Cleveland the first time. And he's from Akron, right? And so I'm asking, hey, how's it going? It's just not going really well. I don't know. I really want to talk about it. Why'd you have me here? I don't know. We just want to talk about it. It's really just depressing. How do you think LeBron will do? I don't know. I don't really want to. Then this one guy's like, how could he leave home for Miami? I just don't see it. I'm like, I don't know. I really... I'm looking outside, my shoes got all the, I grew up in Indiana near a snow belt, so my shoes have been ruined from all the snow plows and stuff. I'm living in Tampa at the time, I'm working in Miami a lot. I'm like, I don't know how he could leave really. I don't understand. I'm puzzled by it as you are. But one of the police officers, there was a bridge there, as there are in many communities, called Suicide Bridge, right? It's where people went to end their lives, or at least to contemplate ending their lives. And the police were frustrated because they would call the mental health center. They just want to know, is this person in treatment, right? You want to know something in the situation. You don't want to know treatment history. Is this, because it might help clarify, is this situational? Is it, what is it? And they're like, no, we can't tell you. And that's, in my view at least, and lawyers here may disagree because lawyers have various opinions about various things, but it would seem to me under the emergency provision of the mental health law of Texas, that would be permitted because the person is clearly in some imminent danger of harm to self or others. Under federal law, and there's a reference at the last slide, which Health and Human Services issued a really, really good guidance on the application of confidentiality law to law enforcement in situations like this. It's a very clear explanation. So if you want to read more about that in terms of application of federal law, it's worth doing. And again, remember, Texas has deliberately tried to conform its law to federal law. So federal guidance is at least vaguely relevant in terms of kind of explicating what the feds meant by the law. So that's Intercept 1. And in Dallas, and I recognize mostly in Houston, it's important to talk about Dallas only to make fun of it, but Texas is great. It's like city-states in the Middle Ages. It's like you got your San Antonio city-state surrounded by that river, and then you got Dallas surrounded by the moat, and then you got, so I mean, I'm cognizant of that. But in Dallas now, there is now been created a system in which the mental health data from the local mental health authority is integrated with the hospital data from 4 participating hospital systems and the arrest data, and it's all held behind a firewall by this data analytics company, to where this initiative that, again, Andy talked about this morning, the Right Care Initiative, which is a mental health person in a squad car with law enforcement, are going to get data feeds indicating that the person they're now seeing has been in treatment or not. And again, it's not copious notes, it's not the whole record, it's simply to try to give a piece of information that the police judge most relevant to disposition. So that's this Intercept. Intercept 2, initial detention. So if you're a sheriff and you're running a jail, or if you're out providing treatment in the community, one of the single biggest discontinuity of care issues is what happens to medication when somebody's put in jail, right? They're taken off their medication, the jail has a closed formulary, they don't know what the person's been on. But there are situations where those issues don't appear, but where the issue is the jail would simply like to know is this person on a medication? And that's permissible under, again, both Texas law and under federal law. And there's 5 specific situations under Hipaa in which information, protected health information, can be given to jail without the person's consent. And it virtually covers everything a jail or correctional facility or juvenile detention does. And again, Texas law largely mirrors that. Now, again, it's not to say we should just indiscriminately start shoving everyone's health records around the world, but it does mean that it is permitted under both Texas and federal law to provide treatment information to correctional facilities. And one reason for that is the interest of continuity of care, which is a major issue, right? Again, if you go back to the Intercept map, every point of possible intervention and every point of possible diversion is also a point of possible discontinuity in care. And one of the points of greatest discontinuity in care is the interruption of medication regimen in jail. And again, sometimes that's for reasons unrelated to confidentiality, but sometimes it's related to the jail simply no one will give the jail the information. Can't tell you, sorry, good luck. And these are these are powerful medications. And I'm also mindful of the fact that one of the themes running through mental health law from when I first got into it 1,000 years ago is just because we think it's the right thing to do doesn't mean we should do it. And there's also this strand of paternalism that runs underneath some portion of this. But when you look at what the law permits, it's useful to start with that and then figure out sort of how to do it, whether to do it, as opposed to, well, the law doesn't permit it at all. So this is the first time, by the way, I've given a talk where this appears to be like a Keurig cup of coffee. So if you see me ingest this or swallow something partway through, it's just to keep myself going for the next 20 minutes. So, yes.
Is that a two-way street? Is that the correctional facility trying to get in contact with other places to find out what their medication is?
Yeah, so the correctional facility wants to know, somebody's arrested and let's say there's a mental health, so the health service in the jail wants to know, we'd like to know what this person's medication regimen, are they on anything? There's a big mental health center in town, so they call the mental health center and ask. Can the mental health center give that information? Yes. Now coming out the back door, there's continuity of care provisions of state law that would permit information to be released for continuity of care purposes between the jail health service and the local mental health authority, as an example. Again, around continuity of care. And again, if you strip away a lot about Hipaa, it is very much in the service of continuity of care. That's kind of the point of the exemptions. Congress got very hung up when it was trying to pass Hipaa before they punted it over to the Health and Human Service on the issue of consent. There was one bill in front of Congress that would have required consent before every exchange of information. There was another bill that would have waived consent for all exchanges of information. What we came out with is sort of this middle ground for payment purposes, healthcare operations, and treatment purposes that authorization was not required. Doesn't mean you can't get it, it just means it's not required. All right, so that's Intercept 2. Now this, I was trying to make the font on this smaller, but I was unable to. But this takes us now to 614.017. This is a law that Texas really pioneered. And when I was in Florida before I came to my senses and came here, this was a statute we all looked to because this statute was the first of its type to try and require a network approach to information sharing. So this is a big statute, and it's had some national play. So if you think about, again, Andy Keller's description of the ideal mental health system looking like the ideal health system, one of the big trends in healthcare is as health systems get bigger and more integrated, they are able to use health information across the entire system. And so one of the points of becoming integrated is you can use the same electronic health record. You have a big enough population, you can understand risk, you can figure out how to match risk to financial profile, et cetera, et cetera. What we're trying to do in this area that you're all working in, we're all working in, is use the legal tools available to create the equivalent of an integrated health system. And the reason we can't do it directly is we all are under different corporate auspices in a sense. We're not the Ascension Seton health system. We're a sheriff's office with a police department, with a local mental health authority, with a hospital district, with a social service agency, with a homeless agency. If all those agencies were under the same corporate roof, we wouldn't be having this discussion, because the corporate roof permits information sharing without any hesitation at all. And again, it's part of why you integrate a system, so you can use information. We're trying to locate and use legal tools to create the equivalent in localities around these issues. And Texas law gives this great tool. So this law says an agency shall accept information relating to a special needs offender, which is somebody basically a juvenile with emotional disorder, adult with mental illness issues, regardless of whether other state law applies. And then you disclose information around continuity of care. That's basically the gist of this statute. Disclose information about the offender's or juvenile's identity, needs, treatment, social, criminal, vocational history, supervision status, compliance with conditions of supervision, medical and mental health history, if the disclosure serves the purpose of continuity of care and service. And again, that's the touchstone for all of this. These are the agencies, and I have very limited PowerPoint skills, and so it took maybe 6 or 8 days to get all this on one slide. It's a productive use of time, really. I went to law school when you still had to, I remember, people think, really, can we end this soon? I remember typing briefs to appeals courts, and writing them on legal paper, then giving them to, at that point, a secretary who said, I can't read your writing. What are you giving me this for? And then you had to make a change with whiteout. Remember, any of you, people are, I remember whiteout, but I'm not going to say. I remember whiteout. So I'm pretty proud that this got this far. But it's virtually yes.
So you have the Texas Education Agency up there.
Yes.
Does that go down to the local level as far as being able to get local schoolers, if you have a juvenile that has IEP issues, that need special education?
Well, you bump up against FERPA, right? And so the federal education law. And so, not to beg the question, but I think you could make out an answer that is yes, but I think what I'd want to do is talk some more specifically about, does FERPA intervene in that context? So again, there's a bit of a dance here between some federal law and Texas law. But the idea for this was really to get mostly to state agencies and governmental agencies that had some play in this area. But the education was a good one. For the Department of Education, U.S. Department of Education, the last, about 3 years ago, amended its regs to try to make the information more useful across systematic or systemic boundaries. So I'd be happy to talk some more about that. Okay. So this is sort of the Texas effort to cause information sharing to occur. And it specifies the development of a memorandum of understanding. How many of you think you have these MOUs in your areas about information sharing? And how many think you don't? And how many have never given it a last thought on earth, right? Like, please, God. I mean, this is an important issue, right? Because one of the things about information exchange is when it's done on an ad hoc basis, it tends to go badly, because in those conversations, they go off the rails pretty quickly into all the issues we've talked about, right? Some legitimate, some less so. And so one of the things that I've talked to, it's The great thing about the Judicial Commission, and Justice Boyce and Christie both already know this, people like me have 1,000 suggestions for things they should be doing or could do. But this is such a big issue, it'd be interesting sort of to see what's out there just for model MOUs, because governance around information sharing is important, because it takes it into the land of more predictability and less ad hoc. Because when it's ad hoc, it's like, I'd like that, and you say no, you want too much. I'm like, well, I really don't want that much. And then people get depressed and go to Akron to see how LeBron's doing. But this statute requires the creation of this kind of framework. And I think the statute to some degree was ahead of its time, because the statute was passed before people actually started thinking about governance frameworks. And now there's a lot of work going on nationally with how you create a governance framework for information exchange, which is essentially what this is. So this is a good exercise, and I know Justice Boyce has this at the top of his priority. All right, so let's go back to the map. There's virtually no circumstance along this continuum in which Texas law doesn't permit or at least strongly favor information sharing. In fact, Section 614 was passed precisely and sort of, as I said, way on the frontier of this issue nationally when it was enacted years ago, to encourage information exchange across this spectrum. In fact, the Texas statute, I think, was passed before intercept mapping was really created, but it anticipated this. People over here on this table are all ducking because they know I'm going to do this whole laser thing right in their face. How's it going over there? So there's virtually no situation or transaction that occurs along this spectrum, again, that information sharing, appropriate information sharing, isn't permitted or at least strongly encouraged. Now, there's some of these transactions that are a bit harder to parse out than others, but generally speaking, the whole premise of Texas law, the whole premise of federal law, is to encourage information sharing in the interest of continuity of care at the various points along this spectrum. And this is the reason the Texas Medical Privacy Act doesn't apply to special needs offenders, because the Texas legislature recognized the needs of that population and the complexity of providing treatment in this multi-system sort of maze we've created as paramount, and that information exchange issues in that context are different than an ordinary practice, or at least that's how I would read the exemption for that. And again, we can talk some more about specific situations or, sort out individual transactions if you'd like, but that is generally the premise or the sort of the spirit of Texas law. So some specific issues. Judge Rice talked about specialty courts today. One of the powers that judges have, and again, to ease concern among treatment providers, if you put somebody on treatment conditions, to ease the concern of other sort of, if I'm a supervising officer and I've got to sort out, as you've now told me I've got to tell you is the person compliant with treatment. There's a couple of things judges can do routinely, and some courts do this, some don't, to put the stamp of judicial approval on the waiver of confidentiality. One is to mandate the waiver of confidentiality as a condition of going on special probation, for example. The other is simply to, and some courts have done this, to have a standing paragraph in any order that basically says confidentiality for purposes of adherence to this order is waived, and treatment providers are either mandated or permitted to share information about the person's adherence, et cetera, et cetera. So there's examples of that. They're relatively simple fixes, and what it does is it gives a treatment provider the assurance that the court actually thought about the issue and mandated it. And so there's ways to plug in judicial action in a way that would make the life of the treatment providers where you're placing folks easier. The second is there's a set of complications that are not unsolvable, but just have to be acknowledged in terms of the way Hipaa deals with court orders and sort of its interplay with Texas law. And so, for example, when all these assessments are being done for mental health under various Texas statutes, it's useful and easy to essentially create a notice to everyone who's being assessed that this information may be provided to the court. And so again, I won't belabor that at this point, but there's ways to deal with the specific interaction of Hipaa with this, with sort of court orders in a way that, again, is not particularly painful. And then I mentioned, and I think if this is in the materials, but a letter from HHSC that was initially issued some time ago, was amended or updated April 24, 2018. And it says, to summarize, and it rehearses all the stuff I've talked about, HHSC requires mental health providers to exchange information in accordance with provisions of 614.017. So again, it's a statutory declaration. It's sort of a regulatory or administrative sort of stamp of approval on that. A clear effort by the Texas legislature to conform Texas law to Hipaa, Hipaa being quite generous in what it permits. And I think it all lines up very nicely for the work you all are trying to do. And again, it's in the interest of continuity of care. Last couple things, substance use is different, 42 CFR Part 2. There was an effort to, this regulation got amended. This deals with substance use and alcohol information, not of every sort, but only that generated by a federally assisted program. I had a police officer once tell me that he had been told when he had investigated a wreck and he thought the person was intoxicated, he could not share that back at headquarters because of 42 CFR. So it's the same myths, right? So a jail doesn't hold itself out as providing substance use treatment. It's not a federally assisted program. So you can talk about in jail about alcohol or substance use issues. You're not included in this regulation. So that's an issue to think about. Security of information is where most vulnerabilities occur. Most people were scared to death by lawyers and vendors, as I said, about privacy issues, but the real vulnerability over and over and over again is the security of the data. And if you think about, there's occasionally stories in the US papers, you may have seen them, about hacking and data systems, right? And the hundreds of millions of records exposed each year that probably every single one in this room has had some record exposed or another. But data security is the issue that often gets short shrift. And there are still counties operating very antiquated data systems. They don't have security officers, and sort of there's a whole set of rules around data protection that we often think less about than we should because we're overanalyzing the privacy part of this. Autonomy, as I said, is still an important value. There are many reasons to obtain somebody's consent before authorizing disclosure of information. Autonomy is an important value in healthcare. We all value it in our own lives. So nothing I've said should be read or heard as at odds with the notion of autonomy. It's simply to try to articulate what the landscape looks like, and then sort of how you deal with that in terms of issues of autonomy, ethical concern, and other things is a matter of judgment. And then, as I said, Texas and Hipaa both place high emphasis on continuity of care. And the last thought I'll leave you with is someone says, Hipaa won't let you do that, does not actually necessarily mean the person knows what Hipaa says. So, thanks very much.
All right, we're going to take a 15-minute break, which means we should reconvene at about 2:05. I want to remind you that after this afternoon's session, there's going to be a reception in the second floor foyer sponsored by the Collin County Criminal Defense Lawyers Association. Please join us at that to continue today's discussion. We will see you back here in 15 minutes.